He didn't specifically say Young Thug's proffer, or he didn't say Williams' proffer.
What up, what up? You back with the answer. We got another one. In this one, we're going to comment and react to Wack breaking down this proffer agreement deal. Now, proffer is a word that floats around a lot on Clubhouse. And what it means is an agreement between the prosecutor and defendant. They got a witness, they got information, they exchange information, and it won't be used against them later. He's going to break that down. We'll get into it. Thanks for tuning in. Let's get it.
Take
Hold
in
on. Hold on. I'm
consideration.
about to
I'm
take it
just
back.
going
Hold
with
on.
this said.
Yeah.
I think Thug gonna stay solid. My bank is he gonna stay solid. When he said that, no, I think Thug gonna stay solid. To be
Let me
honest
That
with
tell
you.
you
means
how I
something.
know. Look, earlier we established the lawyer can't defend the snitch and the
No, but this whole hearing is about Thug. So this anything this judge is reading is pertaining to Thug.
to Thug. I feel it, but check it out. Look, the lawyer that went earlier with the lawyer, like before we even got to
Hold
this
on.
part, they can't defend the snitch and another person on the case, right?
But
Okay. If they saying you can't get a plea, no type of deals without that lawyer, bro, how you get any type of a deal as the number one without telling nothing, bro? He's telling the
We
lawyer.
ain't talking about a deal. Let's
Yo,
go
what
on
is
what he's saying.
bro?
He ain't got
Chill
no
out,
deal,
man.
nothing,
Come
bro.
on,
He
man.
ain't.
Man, we
Yeah.
talking about the co-defendant. We talking about the
Nah,
co-defendant
let's
whose
listen. We
lawyer
gonna
has
listen
stepped
to
up
it.
and took.
Real quick. So, y'all remember in an earlier video on the channel where they got rid of that top flight lawyer. And I think it was because of a conflict of interest where he can't defend two people. Same case was Cody's. Now they on opposing sides. So I believe that's what they referring to. Let's get back to it.
He
Let's
said that he wasn't
listen
going to
to
do
it,
the hearing
bro.
no more. He removed the
Let's
motion
listen
Play
to
and
it,
it,
put it
play
on
bro.
the
it,
Yeah.
bond.
play it, play the tape, man.
All
Play
right.
it.
Y'all said about 20. What'd you say? 21 what?
Okay, about 21:14 and when he started talking. He also said that he might consider, and that don't mean he won't consider later on. So I don't know when he can come back for another bail hearing.
He
But
said 30 days, I think. 30 days.
yeah, I think I still think he got action. And I didn't think he had no action. I knew they wasn't letting him go today. Now, Lord forbid something happened to anybody in a jail or a street. Anything happen, they gonna blame him.
He better speak in codes though.
That nigga better, yeah, he better tell a nigga, boy.
Don't touch the fruit.
I'm gonna tell you what we dealing
Don't
with, and
speak
hey,
at
Eat
all.
Caddy,
the fruit in the
then
basket.
I
I'm gonna
will
tell you
go
what
ahead.
we dealing with, Caddy. Caddy, let me take you back to a movie I know you watched. Get Rich or Die Trying. 50 Cent. Remember when the old man
I
went?
ain't watched that.
You should watch. It's a good movie for real though. Overall, you should.
Now that's funny. Y'all know Cadillac Time, right? Murder Inc. Come on, man. Ja Rule and Wack just asked him if he has the 50 Cent movie. It could be Oscar, whatever, Academy Award. Caddy not touching that. It could be the best movie ever made. That is hilarious. All right, back to it.
Really watch it. Overall, it's a good movie. And
I
you ain't
watched
no
it.
hater
I
though.
watched it. I
So
watched it.
listen.
Okay.
So listen. Remember when the old man and they said bet not nothing happened? And based upon
Okay.
them hitting the police, they pulled the deal off the table because he wanted the old man to stay in jail.
Yeah. You know
Remember
that's
that
real.
part?
Yeah,
Facts,
I know
facts.
that. I know that was based on a real life story from the
No,
hood
no,
too.
no, no, no. I get it, but how they structured it. Remember, it was
Yeah,
the
yeah.
dog was called. Don't nobody do nothing because if anything happened, they're gonna blame it on the old man. He ain't gonna be able to get the deal. He blamed him for it. Actually, he killed two birds with one stone. Have his man, the little greasy, hit the police. He blamed this nigga for calling the shot, saying you knew couldn't nothing happen or the old man deal was gonna be done. So I'm gonna kill you. So he got him out the way, took the number one, and kept the number one in jail. Like you gotta
Mm-hmm.
remember, kids will get
Mm-hmm.
greasy and blame it on him. Can't nothing happen right
And
now.
as I said earlier,
Yeah. Let it
There you
play,
go.
Tweezy. Let it
Let it
play.
play.
on the 18th of August at 9 a.m., we will have a proffer session and we're going to call it waiver session on the record for the various individuals that we indicated earlier. Okay?
Yes, Your Honor. Thank you.
Okay. All right. And Ms. Charlotte, I will set your client's trial for 9 January of 2023. Yes, sir. Okay, all right.
Yo, y'all think is that 21 minutes, nigga?
Yeah, I think it was a little bit before that.
Start at
No,
20.
no, it's
Just
coming up.
start at
It's,
21 minutes, bro.
it's coming up. It's
All right.
coming up, though. I think what you're saying is coming up.
Yeah, I caught it when he came back in, like when after they reset. But it's a long ass recess in between some shit.
All right, folks, before I go ahead and get started,
There you
whatever the
go.
decision is today, this is a forum, a public forum where all are welcome. However, if you feel that you cannot govern your behavior or have acceptable conduct, please,
Right then is
you
when
can
I knew
exit
he
the
was going to deny
courtroom
it.
and nobody will
I
be
knew
the
he was going
wiser.
to deny it.
If you make any outbursts or statements or anything that the law enforcement professionals in this courtroom deem to be inappropriate, you will be removed from the courtroom and maybe subject to other actions. So I just tell you that up front because my deputies are charged with the responsibility of good order and discipline. So whatever my decision is, like it or not, I'll give you an explanation for it, but outbursts were not acceptable, okay? All right. So with that, counsels, I've gone ahead and based upon what has been proffered and the appellate, the case law, I should say, that's been provided to the court, I'll summarize a couple of different things already that you as counsel for the state as well as for the defense, I'm sure aware of. I'm looking at Coleman versus the state, and that's already been cited. That's 361 Georgia Appeals 901. And I'll quote from that decision, which is which comes from our court of appeals. Judge Miller, Val Miller, being the presiding judge in that particular case. Excessive bail is prohibited by the Georgia Constitution, Article 1, Section 1, Paragraph 17, and the Eighth Amendment to the United States Constitution. And for the Eighth Amendment analysis, as you all are aware, that Eighth Amendment violation would be excessive bail or no bail, or fixing an amount that is excessive under the circumstances. When fixing, for the purposes of the Eighth Amendment, the excessive bail is defined as bail set at an amount higher than the amount reasonably calculated to ensure the presence of the defendant. When fixing bail in Georgia, trial judges' foremost consideration is the probability the accused, if freed, will appear at trial, and then the court in Coleman goes on to quote that lesser factors or lesser extent or considerations are the accused's ability to pay, the seriousness of the offense, the accused's character and reputation. I have heard a lot of evidence today about those particular factors in regards to Mr. Williams and his ability to pay and the seriousness of the offenses and his character and reputation from as presented by Mr. Steele, Ms. Hornsby, as well as Mr. Adams. So I have considered those particular issues. Now, also, Coleman goes on to say that a defendant who seeks release on bail has the burden of showing roots in the community. The defendant does not pose a significant risk of fleeing, threatening the community, committing another crime, or intimidating witnesses. And along with this particular case, the court also has considered the seminal case of Ayala versus the state at 262 Georgia 704. And Ayala gives us the framework in Georgia for the purpose of a pretrial bond is to prevent punishment before conviction and secure the appearance of a person for trial, quoting Roberts versus the state, 32 Georgia Appeals 339. And it goes on to say that A trial court may release a person on bail if the court finds the following. So I have to look at the first thing, if Coleman directs me to look at, is consideration of whether or not the
You want to eat curly fries?
foremost consideration is, will he, if freed, appear at trial? And then the lesser factors, and these are: a court may release a person on bail if the court finds, one, poses no significant risk of fleeing from the jurisdiction or failing to appear in the court when required. Two, poses no significant threat or danger to any person, to the community, or property in the community. Three, poses no significant risk of committing any felony pending trial. And poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. And I'm required to explain any reasons if I deny bond to assist the appellate court in its review, and that the granting or denial of bond will not be set aside unless there's a manifest and flagrant abuse of discretion. That's Jernigan versus the state. 111 Georgia 307 pinpoint 308, very old case from 1903. Now, in regards to considering bond for Mr. Williams, I have considered the first consideration is, if free, will he appear at trial, and to a lesser extent, the other factors. And based upon the court's consideration of the proffer, the two things that the court has significant concerns about are him being a danger to the community and flight.
Now
And
stop right
I'll
there.
state
Stop
for the
right
purposes of
there.
the record.
You ain't never lied. That word proffer always raises the eyebrows.
And purposes of my
Stop
decision,
right there.
that
Based upon the consideration of the proffer. Now I'm
Yeah.
asking myself, now Caddy, I'm thinking out loud.
No, but that's the
What
ones they took.
proffer is he considering,
The
right?
ones
Because
when,
that's in his
listen,
ones
hold up.
favor.
against him.
The ones against him, the ones when they were saying that they
The
was
No,
afraid.
he finna get to that. No, hold on. He gets to that after this and says, but the proffers against. See, this, he's saying in consideration of the proffer, right? No, he's talking about, right, what's in his favor. Watch, let it play. Now he gonna talk about the ones against him. So what the fuck is, yeah, play it. Keep let it play.
I realize that Mr. Williams is presumed innocent. I realize that he has the presumption of innocence stays with him until the state, by sufficient evidence, is able to prove to a jury's satisfaction beyond a reasonable doubt, I should say, that he is guilty of the offense or offenses charged. But however, in this particular circumstance, there has been significant proffers about Mr. Williams as being a danger to the community. In particular, the state's proffer that they have taken proffers from other gang members and people who are in this particular indictment and they're not in this indictment, that he is the leader of the gang, he is dangerous, and if he crosses them, he'll kill them or their families. And the predicate or the review of the state.
So did we just hear? Did we just hear that there was proffers for and against him? So out of those 28, 27 not including Thug. Yeah, man, they scrambling.
The concerns that I have are
So stop it right there. So now we established before this happened that now some of them codees had already turned. He just established that.
That's a fact.
He said proffers that's in this indictment and proffers that's not in this indictment. Some of the codees in turn. We don't know which ones, but he just established that.
Wack
But what's
called that
fucking
a
me
few
up
weeks ago.
is, rewind that a little bit, Tweezy, because he said, I take into consideration the proffer, and then he goes to talking about the ones against him.
Or
I
property in
think
the
they talk about all
community.
the prophets against him.
3, poses no significant risk of committing any felony pending trial. and poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. And I'm required to explain any reasons if I deny bond to assist the appellate court in its review, and that the granting or denial of bond will not be set aside unless there's a manifest and flagrant abuse of discretion. That's Jernigan versus the state. 111 Georgia 307 pinpoint 308, very old case from 1903. Now, in regards to considering bond for Mr. Williams, I have considered the first consideration is if free, will he appear at trial, and to a lesser extent, the other factors. And based upon the court's consideration of the proffer, the two things that the court has significant concerns about are him being a danger to the community and flight. And I'll state for the purposes of the record and purposes of my decision that I realize that Mr. Williams is presumed innocent. I realize that he has the presumption of innocence stays with him until the state, by sufficient evidence, is able to
So
prove
stop right there,
Sounds
Queasy.
like a butt coming.
How I'm hearing it, I could be hearing it wrong, is everything he's talking up to this point is what's supposed to be in Thug's favor, even the proffer. So now you say, well, what proffer is in his favor? Now in his defense, he didn't specifically say Young Thug's proffer or Mr. What's the last name, Williams or something. He didn't
Yeah,
he didn't
that's his
say
name.
he didn't say Williams proffer, but I'm like, when he said it, I'm like, what proffer is he considering? And he's saying he's innocent, presumed guilty. Then he goes to talk about the proffers that's against him. So how I heard it was, is he talking about the proffers that's in his favor? If so, what proffer would be in his favor? That's the air need to clear right there. Because he's established what's against him. He's saying it's Cody's people that's in the indictment and some people that's outside the indictment. He's read those proffers. But then at the beginning he says, I considered the proffer and I considered Young Thug being innocent to presuming guilty. What is he, what exactly is he talking about? Because he's clearly identifying one proffer that's in his favor and several that's not. Now that's just what I heard. So I'm gonna let the float have a conversation about it. And again, he never said I'm considering Mr. Williams or Young Thug's proffer, but he said I'm considering the proffer and I'm considering him, being innocent to presume guilty. But then I also have to consider the proffers against him, which is all these people that's telling on him that's in the indictment, outside the indictment.
Well, y'all heard it. There's proffers for, proffers against. It doesn't implicate Young Thug, last name Williams, in terms of being involved in one of those agreements. We'll see how it plays out. We'll keep you abreast. Once again, like, share, comment, subscribe. I appreciate y'all tuning in. We out.